Professor Porter. We're talking about criminal law, specifically a set of crimes called inchoate crimes. We've discussed already some of the other inchoate crimes, attempt, solicitation, accomplice liabilities in here. But today we're talking about conspiracy. And similar to the other inchoate crimes, we're really talking about a heightened level of mens rea that's required. So it doesn't matter if it's a specific intent crime or general intent crime at common law. Here, if you're going to conspire to commit a crime, we need a specific intent to commit that underlying crime. So the common example is if it's murder, regardless of the different levels of intent that may be acceptable to murder at common law and even under a statute, we're going to need a specific intent to kill as someone who conspires to murder. And with that sort of heightened level of mens rea, there's a lesser level of actus, and the actus here is just an agreement. It's an agreement by two or more people. So it's not the normal actus that we would think of physical, willful movement, doing something, picking up the brick and throwing it at someone, pulling the trigger, those types of actuses for murder. Instead, now we have a conspiracy. We have that heightened mens rea factor, but we also have the agreement is the crime itself. So the right thing going on between the ears for the criminal mind and an agreement between two or more people. And we're careful to say agreement between two or more people because it doesn't necessarily have to be the defendant. The defendant could join in the conspiracy later when two other people have agreed to sort of commit the crime or commit certain objects and goals of the conspiracy that involve different crimes. And then you're going to find when we turn to our statutes, this is common law, this is common law conspiracy. Turn to our statutes, most of them have an additional requirement of some type of overt act by one of the conspirators. Again, it might not be an overt act committed by the defendant in this case, but it's a step taken, something. Doesn't need to be a crime in and of itself, could be a phone call, could be a meeting, but the specific intent, what's going on in the brain, the agreement between two or more people, and some act taken by one of those conspirators that sort of evidences the agreement in that specific intent. These are the elements of conspiracy, and I think it differs in somewhat between what people may think of when they think of conspiracy, before studying it. So some of the issues that we'll talk about, again, looking at those, that actus requirement, whether there was an overt act taken, whether an overt act is required, and studying and looking at who committed it, are they in the conspiracy. We saw with attempt, particularly incomplete attempts, we saw mere preparation as being the defense argument before taking some type of substantial step or taking the requisite aggregate measures to go in the direction of the crime. Here it's kind of like, if you're just present in the house when people are agreeing to commit a crime, you might argue as the defense side, mere presence. I'm not one of the conspirators because I was sitting in the living room when this robbery was being discussed, or they were agreeing to commit a robbery. I was merely present at the time. So that's a popular defense argument and sort of defense to the actus, right? I did not agree, I was merely present. Again, we're talking about specific intent, and you have to have kind of that two-part. So all inchoate crimes require a specific intent to commit the underlying crime, or here what's raised as accomplish the object or the crimes that are the goals of the conspiracy. But you also have to have that first intent, that intent to conspire, that intent to agree. And then some of the issues that come up is, did you join? Do you have knowledge of what's going on in the conspiracy? Were you able to withdraw, at least cut off the liability of the conspiracy? A lot of this is going to flow from a case called Pinkerton that we discussed. We're really talking about, essentially actions of the conspiracy that could happen, and it could happen that you joined a conspiracy and that other people took actions. You might not know who they are, and you might not know what they're doing, but you could be sort of culpable for their actions because you've joined a conspiracy and it's foreseeable. So here are some of the issues that come up and some of the defense arguments that flow from it. That actus requirement, the heightened specific intent, and essentially the two intents that are required for any inchoate and conspiracy being no exception. And then kind of the when did you join, how did you acquiesce to the being in the conspiracy, knowledge of what's going on in the conspiracy, and then arguments that you withdrew and communicated your withdrawal to other people. Let's look at the jury instructions. Here's an example from the Ninth Circuit. This is a typical statutory structure. You can see there was an agreement between two or more persons to commit at least one crime as charged in the indictment. Usually you have a conspiracy count that is count one in an indictment, and it'll say to commit the robbery, to commit the murder, to commit the substantive crime. That's reflected in count two or other counts that are below. So again, it's not saying the defendant and someone else agreed, two or more persons agreed to commit that crime. And here you see that this is the membership part. It became a member of the conspiracy knowing of at least one of its objects. So it's kind of became a member and knows what's going on and has that specific intent element. He's intending to help, he's intending to be part of it. And then here's the statutory requirement, which the Ninth Circuit follows according to the Model Penal Code, which is there has to be at least one overt act. That somebody did something in the conspiracy to move this operation forward. So those are sort of how you discuss typical elements under a statute, and this is how the jury would be discussed. There's an agreement, there's at least knowledge of what's going on, and that he intended to join and accomplish those goals of the conspiracy, and then there's one overt act, at least one overt act. And typically in an indictment they would list out many overt acts that are taken in the direction of the conspiracy, and the jury would just find just one to find the defendants guilty if they did in fact join and it was an agreement that was proved. So I like looking at the cases that we look at, what happened, what's the underlying crime, conspiracy to do what? Was it conspiracy to rob the bank, conspiracy to commit the murder, conspiracy to do what? Sometimes it's a broad overarching conspiracy that involves many different crimes. They're trying to defraud people, and they're trying to launder the money, and they're trying to enrich themselves. There could be many goals, many objects of the conspiracy. What is that sort of evidence that two or more people agreed? And furthermore, if the defendant's not one of the people that agreed at the front end, maybe you have A, B, C, D that committed the robbery. A and B were the ones that were in the home in the beginning, and they agreed, and then C and D joined later, or were asked to join later, and showed up on game day. So you have circumstantial evidence that they have joined the conspiracy, they agreed. If the statute requires it, if you're given a statute and it requires an overt act, what is that overt act? Because oftentimes we're talking about an inchoate offense, so we might not get to the robbery itself. When it comes down to the issue of merger that we'll discuss in the context of all inchoate crimes, you can have conspiracy and you can have the underlying robbery, and they can both exist. You can be found guilty of one and two, conspiracy to commit robbery and robbery. But what is, assuming that they've just agreed and that they're just going in the direction of the crime and they don't commit the crime, it stays as a sort of incomplete crime. What overt acts did they take? What steps were taken? That evidences the conspiracy, the agreement, and the heightened intent. What were the objects? What were the scope of this conspiracy? And then some of those Pinkerton issues. Were they able to? What are they on the hook for as far as what went on in the conspiracy and potential withdrawal, potential cutting off future culpability, so on and so forth. So I read cases and kind of think of these.